Thanks for joining us for the latest episode of Kelleher and Holland's Employment Law Lunch and Learn webinars. Our panelists serving today's specials are Andy Bowling and Madeline Kelleher from our Employment Law Group. And let's just get things started, and I will turn it over to Madeline to get us cooking.
Thanks, Amy. So good afternoon, everyone. We're here today to discuss some recent changes in federal law that have a huge impact on employment law nationally. On April 23rd of this year, two big decisions were made by both the Federal Trade Commission, commonly known as the FTC, and the Federal Department of Labor. So first, the Department of Labor updated and revised the regulations issued under the Fair Labor Standards Act, or you might hear us call it the FLSA, by issuing a final rule that expands overtime protections. Briefly, generally, the FLSA establishes minimum wage, overtime pay, record-keeping requirements, and child labor standards, and is enforced by the Wage and Hour Division of the United States Department of Labor. But in today's Lunch and Learn, we will be focusing solely on the new federal rule regarding overtime.
So let's start with the DOL's changes to the overtime exemption rules. What is the FLSA, and what is their definition of an exempt employee?
So in the overtime context, the FLSA generally requires covered employers to pay employees both minimum wage and for employees who work more than 40 hours a week, overtime pay of at least 1.5 times, so 1.5 times, an employee's regular rate of pay. There are some workers who are classified as exempt from the FLSA overtime pay requirements, including bona fide executive, administrative, professional, outside sales, and computer employees. But today we will be mainly focusing on the executive, administrative, and professional employees. So this exemption will apply when an employee's paid wages, as you can see on your screen, paid wages past the minimum threshold requirement, which is currently $684 per week, and it comes out to $35,568 annually. And the employee primarily performs the requisite duties of the executive, administrative, or professional. As the duties are different for each of executive, administrative, and professional workers, and we'll go through them briefly. As you can see on your screen, executives are exempt from overtime pay requirements under the Fair Labor Standards Act if they meet the minimum compensation threshold requirement. Their primary duty consists of the management of the enterprise or department or subdivision of the enterprise. They customarily and regularly direct the work of two or more employees, and they either have the authority to hire and fire employees, or their recommendations as to hiring, firing, advancement, promotion, or a change of status for the employee are given particular weight. So all of these things you'll see throughout each of the exempt duties and requirements, they all have to apply. You know, the executive has to meet all four of those duty requirements. So then on top of those four duty requirements and, kind of to the side here, there's an additional overtime exempt option for executives to be automatically considered exempt if the executive owns 20% or more equity interest in the company and is actively engaged in management of the enterprise. So examples of executives that are commonly exempt from the Fair Labor Standards Act overtime requirements include CEOs and other C-suite level employees, mid-level managers, shift managers, and, for example, executive chefs. Next, we'll move on to administrative workers. They are exempt if, first, they meet the minimum compensation threshold requirement. Their primary duty is the performance of office or non-manual work, specifically non-manual work, directly related to management policies or general business operations. And this really truly means the general business operations of the company. So, for example, accounting, marketing, human resources, and the like. And then third, they also must exercise their own discretion and independent judgment with respect to matters of significance. And so they can't just follow well-established techniques and procedures. It has to be really something that they have input in and can choose what they do and how things work at their discretion. So to meet this directly related to management or general business operations requirement, an employee must perform work directly relating to assisting with the running or servicing of the business, as I was briefly discussing. And this is very distinguished, for example, from working on a manufacturing production line or selling a product in a retail or service establishment. And then work directly related to management or general business operations includes, but is not limited to, work in functional areas such as those that are listed on the slide and similar activities. So some examples of commonly exempt administrative workers include human resources managers, in-house accountants, office managers, insurance claim adjusters, and assistants to senior executives or business owners. Next, we'll move on to exempt professionals. So there are two classifications for exempt professionals. It can either be a learned professional or a creative professional. Let's go through learned professional first. To qualify for the learned professional employee exemption, all of the following must be met. They must meet the minimum compensation threshold requirement. Their primary duty must consist of performance of work requiring knowledge of an advanced type in a field of science or learning, customarily acquired by a prolonged course of specialized intellectual instruction and study. And they must consistently exercise discretion and independent judgment. Some examples, as you can see on the screen, of commonly exempt learned professionals include lawyers, teachers, doctors, accountants, pharmacists, and engineers. We'll move on to the creative professional employee exemption. So to qualify for this, they must meet all of the following: the minimum compensation threshold requirement, and the employee's primary duty must be the performance of work requiring invention, imagination, originality, or talent in a recognized field of artistic or creative endeavor. And you can see some commonly exempt creative professionals would include actors, writers, musicians, novelists, cartoonists, certain painters and soloists, things you would commonly see in a recognized field of artistic or creative endeavor. And additionally, those employees that meet the annual compensation threshold of highly compensated employees are also exempt from overtime pay requirements. Currently, a highly compensated employee is deemed exempt under the Fair Labor Standards Act if the employee earns a total compensation of $107,432 or more, which will include the at least $684 per week paid on a salary or free basis. So the minimum per week has to at least be $684 currently. Next, the primary duty of the employee must include performing office or non-manual work, and the employee has to customarily and regularly perform at least one of the exempt duties or responsibilities that we just went through of an exempt executive, administrative, or professional employee. So, for example, an employee may qualify as an exempt highly compensated executive if the employee customarily and regularly directs the work of two or more other employees, even though the employee does not meet any of the other requirements in the standard test for exemption as an executive. And that's pretty much a brief overview of the duties and classifications under the Fair Labor Standards Act of overtime.
Perfect, Madeline. So now let's get into what changes were made regarding exemption from overtime pay.
Sure. So as I mentioned, the Department of Labor released a final rule that raises the wage threshold for these certain overtime exemptions under the FLSA. The three significant revisions include increasing the standard wage level, increasing the highly compensated employee total annual compensation threshold, and adding to the regulations a mechanism that will now allow for the timely and efficient updating of the wage and compensation thresholds to reflect earnings growth over the years. So we'll start with the standard wage level. As I mentioned, the current wage threshold for bona fide executive, administrative, and professional employees is $684 per week, which annualizes to $35,568 per year. The new final rule calls for an increase in the threshold to $844 per week, which annualizes to $43,888 per year. So this will start on July of 2024, July 1st, and then it will increase again to adjust again on January 1st, 2025 to $1,128 per week, which comes out to $58,656 per year. Just a quick brief reminder, this is, you do not have to be on salary to be considered exempt. They are looking at it as a weekly wage threshold, not just salary. So I also mentioned previously, moving on to the highly compensated employee, that this wage threshold was currently $107,432 per year, which includes at least $684 per week on a salary or fee basis. And now under the final rule, this threshold will increase to $132,964 per year on July 1st of 2024, which will then, of course, include the $844 per week on a salary or fee basis. And then, same as the regular standard wage level, for the highly compensated employee wage level, it will also on January 1st, 2025, increase to $151,164 per year, and that will include the $1,128 per week salary or fee basis threshold. And then the automatic threshold updates. So the third thing that I pointed out that of the revisions of the final rule. So of these new on top of the wage thresholds, starting July 1st of 2027, the thresholds will update every 3 years by applying up-to-date wage data to determine the new wage levels. Previously, the wage thresholds have been updated seriously randomly since the inception of the Fair Labor Standards Act in 1938, with updates in 1975, then it jumped all the way to 2004, then to 2016 and 2020. So the Department of Labor provided that the purpose of these new 3-year automatic updates is to, and I quote, keep pace with the changes in worker salaries, ensuring that employers can adapt more easily because they'll know when salary updates will happen and how they'll be calculated.
So what about state laws, Madeline? Do these changes override them?
Yes and no. So the Fair Labor Standards Act sets a floor of minimum protections regarding overtime. No state can impose rights that are less than those provided under the Fair Labor Standards Act. However, many states and local governments can legally require more generous treatment to employees. Employers must always follow the law that provides the greatest protection for workers. Many states, counties, and even cities have their own wage and hour laws that they regulate and enforce. Some are similar to the Fair Labor Standards Act, but some differ and are more employee friendly.
So what should employers do now?
So with these changes, employers now must either raise the salaries paid to their exempt employees to maintain the exemption or reclassify their positions to non-exempt and pay them overtime. To do this, employers should perform an internal audit of the current duties and compensation of each of its employees to make sure that they're properly classified as exempt, and then make a decision on how to proceed. We highly recommend that this audit be done with the assistance of an attorney to ensure proper classification, as the consequences of misclassification can be steep. Employers must also consider the pros and cons of reclassifying employees as non-exempt. There are some morale concerns. Why am I being treated as merely hourly now? Am I being demoted? Will reclassification inspire an employee to claim they were misclassified originally as exempt and then be able to claim back pay of overtime? There's also an economic analysis that has to be considered, right? So if the exemption is valid, will the company save money by reclassifying based on potential overtime? Might it it might be less expensive in the long run to boost the base compensation. And then consider the option, subject to state law, of the fluctuating workweek method and the possibility in this method of only paying a half time above the regular rate of pay for overtime rather than time and a half.
For more information on our employment law services or any of our other practice areas, visit kelleherholland.com or send us an email to attorneys@kelleherholland.com. Kelleher & Holland's Employment Law Lunch and Learns are prepared for the general information of clients and friends of the firm. It is not intended to provide legal advice with respect to any specific matter, nor is it intended to create an attorney-client relationship. Under rules applicable to the professional conduct of attorneys in various jurisdictions, this may be considered attorney advertising material.